Alright, welcome to the role and responsibilities of a guardian ad litem. My name is Lexi and I have been a member of the Nebraska Foster Youth Council for over 2 years now. All I ever wanted was to be heard and not just dismissed. This quote from my youth in foster care is common. Youth have rarely been allowed to participate in their dependency court hearings. The 2006 amendment to the Promoting Safe and Stable Families program now requires the court to consult with the child in an age-appropriate manner about the child's permanency plan. As a result, many courts are starting to implement policies and procedures to involve youth in their dependency hearings. This session will focus on the guardian ad litem's role in encouraging youth involvement and preparing for and debriefing youth about their court involvement. Our speaker today is Andrea Khoury. Andrea is the director of the ABA Youth at Risk Bar Youth Empowerment Project, focusing on adolescents' access to attorneys, children's right to counsel, and youth involvement in court hearings. Please help me welcome Ms. Khoury.
So on her little paper, it actually says, clap now and shake her hand. So I was like, all right, here we go. Gotta clap, shake her hand. We're all set. Excellent job, excellent job. Well, I just want to thank everyone for coming here today to talk about how to include youth in their court hearings. The trend has really been in the past to not include kids during the court hearings. The courtroom really hasn't been a place for kids to be involved. You know, the dockets are long, the hearings are short, in and out. Kids often stay in the hall room, in the hallway for hours, waiting for their court hearings to start. And we're going to talk about kind of how the change is starting to happen and how we're really trying to involve kids in their court hearings. The Bar Youth Empowerment Project, which is a partnership with the Casey programs, that project, the overarching kind of goal of the project is to improve outcomes for kids as they age out of care. And one of the ways that we are trying to do that is to really include kids more in their court hearings. As we've traveled around talking to kids about their cases, about permanency planning, what we have heard is that they're not feeling like they're included, that they're not feeling like what they say is really taken into account. And they understand that there's this thing called a court hearing, and there's this person called a judge. And what they're not feeling like is that the judge is able, is being given the opportunity to kind of hear from them. So because of that, as I said, we are starting to really do some trainings around this issue and starting to change how things have happened. And so that's why I'm here. That's kind of the portion of the project that brings me. And one of the largest component to involving kids in their court hearings is their attorneys, is their advocates, is the guardians ad litem. How do we ensure that they're present? How do we ensure that they're prepared? How do we just ensure that the court hearing allows the kids to feel empowered, as well as allows the judge to get information from the child? So that's kind of what we're going to be talking about here. I want to get an idea. You can come on in. There's seats over there. I want to just get an idea of who's in the room. I know that this workshop is sort of geared towards guardians ad litem. Is anyone here not a guardian ad litem? Okay. Is anyone here not a CASA or a guardian ad litem, court appointed special advocate? Okay. What are you guys? Health and Human. Okay. Health and Human. Okay. All right. Great. Others that are not classes or guardians ad litem?
Foster care review board.
Okay, excellent. Anyone else? That's good. Okay, I just wanted to get an idea of who's in the room. Go ahead.
Nebraska Foster Youth Council, Nebraska Children's Association.
Excellent, excellent. Then I'm going to want to hear a lot from you all during this workshop. So what I'm hoping to do is this to be extremely interactive. I want to hear from you about what you need to know and kind of what your thoughts are about involving kids in their court hearings. So we're going to go ahead and get started. This is a quote that I've heard over and over again when I've talked with youth about their court hearings. It's just that they want to be heard, that they want their voice to come out and to really feel empowered. And so as I was saying, that the trend used to be to not include kids in their court hearings. And that trend is changing. And that really sort of started at the feds. The feds passed the Child and Family Service Improvement Act of 2006. And what that said was that the judge, so it places the burden on the court. The court has to consult in an age-appropriate way with the child about their permanency plan during their permanency hearing. So, again, the burden is placed on the judge and they have to consult with the child. What does consult mean? We posed the question to HHS, who issues statements on behalf of the feds under this statute. And the feds actually said that they were going to interpret the term consult not to require that that the judge actually see the youth and talk to the youth, but that they were going to say that what has to happen is the judge has to find out what the youth thinks about the permanency plan. What is the youth's opinion about the permanency plan? So not just what some person thinks is in the child's best interest about the permanency plan, but for example, if the permanency plan is adoption, does the youth want to be adopted? And so they focused on really the opinion of the child. And what this sort of indicated to us is that an increasing importance placed on child involvement, on what the child thinks about things, really trying to get the child's buy-in towards the permanency plan. So that's how the feds interpreted the term consult. There's really only one case that, at least that I have found, that really talks about how to interpret this statute. And it was a New York case, and the facts just really quickly were that there was a teenager and he asked to be included in his court hearing. And the child welfare agency said no, that they did not want the child involved in the court hearing because he had a history of acting out after he was ever in attendance at his court hearings. And so they had a hearing on that. And the judge said that that was not a good enough reason to exclude a child from the court hearing. That the statute really was designed to ensure that the judge actually see the child and actually have a discussion with the child about the permanency plan, about the placement, about anything that the child wanted to talk to the judge about. So that's really the only case that's on point when it comes to interpreting the term consult. I just put this up here, and I think you all have the PowerPoints in your thing here, your drive. And I think also on this you have a couple articles that we wrote at the ABA, and they go into a lot more detail kind of about what all of the agencies think about involving youth in their court hearing. But here's sort of a list of kind of the who's who of child welfare in the courts. And each of these agencies say that it is important to involve kids in their court hearings at some point. So I just put that up there, and I would encourage you to go to the articles to kind of read their interpretation of the term consult. I also just put this up here just to kind of talk about what other states have done. A lot of other states sort of use as a bright line rule age. You know, kids over the age of 12, kids under the age of 12. And that's one way to sort of determine who's going to come to court. And I think that's, I want to spend some time with you all talking about which children you think should come to court. Should we have a criteria for if a child comes to court or not? Should all kids come to court? And so these are just some examples of what states have done. But what you're really interested in is what your state says. And so, so under your statute, again, the burden seems to be placed on the court, is that the court is gonna provide notice, and the right of participation in the court hearings. And then it comes all the way down, and 3 is the foster child is age 14 or over. So that's what your statute says on it. So kids older than 14 get notice as well as the opportunity to be heard. Thoughts on this? Are the courts giving notice to kids over the age of 14? Is that happening?
What do you mean, what's the practical application of that? A letter from the judge to the 14-year-old? Is it to the department?
The same way.
What are you saying?
The same way that notice is provided to the person charged with care of such child and the person's parents or guardian. So the same way that notice is provided in your state to parents and to the person charged with care of the child, the court has to be giving that same notice to the child. Usually it's the guardian ad litem or the CASA. Is that happening?
Is the person charged with care the foster parents or HHS? Because typically, the order for hearing goes out and it goes to HHS, to the guardian ad litem, to the county attorney. Guardian ad litem will typically then send a letter to the client saying, here's your court date, here's what's going on. Should the court also send notice directly to the foster parents so they know?
Right. It would be my interpretation that it says person, but usually notice also has to go to the child welfare agency. So I would interpret that, and I could probably, the folks here from the child welfare agency could clear it up, but I would interpret one to be the child welfare agency gets notice of the court hearing.
And that would be up to them to provide the foster parents notice, here's when the
Exactly.
hearing is. Because obviously
Exactly.
they may or may
But
not
it's-
find out from the child.
Right, but it's still, I mean, there's an independent requirement for the child's parents, obviously, as well as the child. So even if the child welfare agency is giving notice to the guardian ad litem, there's an independent requirement from the court to give notice to this child. And so I think from what you're saying, that the court does give notice to the guardian ad litem.
Yes, and I think the court would consider that the notice to the child.
Absolutely. Anyone not getting that? Okay.
I think guardian ad litem, they're always on the certificate of service for everything.
Yeah. Absolutely. Great. Okay. All right. Now we're going to talk about how that sort of plays out. Now that you're getting notice of the court hearing, I want to talk about, should children come to court? Should they come to court? And I always like to start this out by talking about, why do you think it would be important for a child to come to court? What are some of the benefits for having a youth attend their court hearings? Thoughts? Yes?
Because they're getting conflicting information from so many other sources about what's happening.
Absolutely. We've heard that from youth across the country. They will get information from the parent, from the foster parent, from the caseworker, all different kinds of information, and often they conflict. They aren't the same. Whereas if a child comes to court, there's a judge who's talking about this information and trying to sort out all of the things the child has heard. So the child is able to hear what's actually happening in their case. Oftentimes we've heard that the kids hear from their parents, I'm doing everything the agency is telling me to do. I'm going to my drug treatment, I'm going to my parenting classes, and then they get into court and they hear from the judge that the parent is not actually doing all of those things, and it's not actually the state's fault that the child is not able to go home.
I just think it's a really good opportunity for a child to have a way to interact with the court system in a positive manner, because a lot of these kids, what they know the court is, my parents, my brother, my uncle, whoever keeps me in court, the judge keeps me in jail, the judge did that. And you know, where I'm from, the judges are really good at this, support. and they're very, very including the mental health. I think that's just a huge benefit to the kids.
Absolutely. So a lot of times kids have this idea about court, what they see from their parents or their brother or their aunt, that when they go to court, they end up in jail. And so coming to this kind of a court hearing, it can give them a better view of the courts. Absolutely right. And especially if the judge involves them in the court hearings, asking them for their input. Excellent. Other reasons that it would be important, sure.
There's a sense of empowerment and control over their own lives. And no one wants other people making decisions for their lives, including children and young people. And so not only do they feel like my life is worth working for and having a say in what's going on, but then taking that ownership and responsibility for their own personal behaviors. And knowing that every 6 months somebody will be holding me accountable, and I need to take that personal responsibility.
Absolutely. I think you talk about 2 points. One, empowerment. To actually be present at the court. Again, a lot of our kids know that there's this thing called court and there's a judge. And to actually be involved in that, to know that the judge is taking into account what they have to say is extremely empowering. Even if the judge doesn't do ultimately what they're asking the judge to do, to understand that they actually have a say, that they have some amount of input into what the judge is talking about. And then also taking some sense of accountability for their own actions. If they're older kids and they have a case plan and they have to do well in school and they have to have a job, that coming to court they understand that there's going to be a judge who cares about them, who's going to be asking these questions. Are you doing the things in the case plan that we have talked about? So excellent. Other ideas about why it would be important for a child to attend their court hearings. How about anything for the court? The judge. I mean, we talked about why it's important for the youth to come to court hearings, but is it important for the court? Yeah.
I'd say so, because the judge can put a face with the name. He can see how the kids behaving, how the kids doing things.
Absolutely, absolutely. That the judge, instead of having 25 files on his or her desk, that there's actually a child, that we're actually talking about this child. That the judge is actually going to decide things about this child and what's going to happen. Placement, permanency, school, to actually have put a face to a file. That's excellent. Other things.
I think sometimes the judge can actually see the relationship between the parent and child, particularly as you're going along toward conflict beautification. They can really see that, well, yeah, this child really has a relationship with the parent, or no, the child's under the table and the parent has no say, and the child is little done at all.
Yeah, absolutely. Seeing how the child not just interacts with parents, but interacts with foster parents if they're there, interacts with their attorney, interacts with other people in the court. A judge can gain a lot of insight into just observing how they interact with people. Excellent. Other thoughts? Yes.
The judge can actually tell the child what he wants the child to do, and he can also observe how the child responds to that direction. Of course, we see it happen both ways, but they're very respectful of the court, and I've also seen it absolutely disrespectful.
Right.
When the judge gets a real flavor for what the department and everybody else is doing.
Absolutely, absolutely. Actually having the child hear from the judge what the judge wants the child to do. I was talking to a youth once who told me that when she isn't at court hearings, it's like that game that we play where you tell a person in their ear a story, and she tells a person in her ear, and she tells a person in her ear, and then inevitably the person at the end has a different story than how it started. And so the child feels it that's the same kind of way. It goes through. It goes from the court to the guardian ad litem to a counselor to the child. And so actually being present, the child can hear from the judge. These are the things that have to happen either for my parent or even for me. These are the things I have to do, and be able to ask questions and interact. So excellent point. Any other? Yeah.
I think it's it's also really important for the young people to be able to hear where the parents stand. I think, you know, in visits and things, parents might be saying, well, I'm doing everything that I can, or I do love you and I want this to work. However, when it comes down to it, when they go to court, they're not doing what they need to be doing to go home. And I think the young people a lot of times will put all that blame on foster parents or caseworkers or their CASA or anybody else and be angry at them and not at the parent. And I think that very real and that very honest communication and seeing that, you know what, this isn't my caseworker's fault or this isn't my foster parent's fault, this is my parent who's not saying what they feel. I think it's very important, not only for them to know the truth, but for healing and processing,
right,
and being able to move forward and have that, okay, this is what I need to do for myself, or this is why
Right,
this decision
right.
is made.
Yeah, I mean,
But that's interesting, because I always felt like I wanted to protect the kid from that. You know, I always felt like, oh, I don't want the kids to hear, you know, the things that might be said to the parent or the parent revealing it. So that's interesting to hear us say that. So that was one reason I thought, well, maybe I don't want them to go, is because they hear that stuff, but it's really the opposite.
yeah.
And I had a discussion with one of my judges who questioned what the child being there, because we were talking about issues related to the child and the child's behavior and that kind of thing. And basically my response to everybody was, the child already knows. I mean, but they have perhaps misinformation.
Right,
But they already know that they have problems. They already know that the parents have problems. They already know that the visits aren't occurring or all of these things. So we're not protecting them from the process by getting them out of court. We're allowing other people to manipulate by getting them out of the court process.
Right, excellent point.
I think it depends on the age, honestly. I mean, you have kids who, you're bringing the kids and parents in from jail, and they have to sit there for hours to get to their court hearing. And yeah, they know what's going on, but then you're dealing with the embarrassment. You're dealing with the fact that we're keeping them out of school for hours and hours, and they haven't been attending anyway, because the parents haven't gotten them there. And I think when we're dealing with older kids, yeah, they want to be there, they understand what's going on, they have, I don't know, it's, a little difference. But when you're dealing with younger kids, I don't think it's appropriate. And I have tons of kids say, I don't want to be there. It makes me nervous. It makes me scared. I don't want to see my parent like that. And if you are a good guardian ad litem and you have a relationship with your child where, you can tell them what's going on, you can communicate what they want the court to know, I think you really have to take that into consideration, because if we just go across the board, oh yes, we should have kids in court and it's great, but when do we ever hear from foster kids that are 3, 8, 10? No, we hear from foster kids who are 18, out of the system, and not involved. And there's a big difference, and I think that people don't get that.
Okay, and we're absolutely going to talk about that. I just want to just sort of reinforce what you all were saying, and that's that we have this kind of view that we want to protect our kids from hearing these things, and I kind of challenge you to sort of broaden your view of how we protect kids. And oftentimes, and not always, you're absolutely right, and we can talk about that too, but oftentimes protecting kids is allowing them to see what's actually happening. And I'm not standing up here saying that we should just plop kids down in court with no sort of preparation, and then even more importantly, what's going to happen afterward, after they kind of hear about their parents not doing the things that they have to do in order to get them back. How are we going to support the kids afterwards? Do they have to get into counseling, or any of those kinds of things that all have to be taken into account? Okay, any more positive things before we kind of address the other? Okay, so I want to hear your concerns about youth coming to court, and I think that we have a first concern in terms of age, and I agree that I don't think that, as I said, I'm not sitting up here saying all kids should come to all court hearings. There's got to be factors that we involve, and I think age is one of them. Other kinds of, yes?
The other problem I have sometimes is if I have an older sibling who particularly is a victim of sexual abuse, and I have a younger sibling, we typically talk about cases together. You don't separate siblings out. So we won't typically have or want siblings together in those kinds of cases.
Right. Okay, so what are people's thoughts on that? Because it's an important one. If you have two kids that have two different kinds of issues going on, both kids are out of the home. How do we handle it? Let's say both kids have said, I want to come to court. How are we handling
I
that?
think one of the things though also is that with siblings, they still love each other and they still want to see each other, and I think that's a healthy, positive way they could see each other. People will be there watching, if both of them want to be there, they won't be alone together.
But the
And
problem
if
we
they
have
don't-
is that if the younger one doesn't have all the
Information.
about the abuse
The
for
older
the older
one's case,
child.
how do we sort of,
Right.
The older child doesn't want the younger child to be there, even though, I have twins, that's what my case is. Boy and a girl who are twins, and so they're the same age. And the girl who was sexually abused does not want her brother
to know
to
about?
know all the details. I mean, he certainly knows her in court, he knows that there's an issue, but the details in this case are particularly, graphic.
Okay, yep.
I think we've got some really good CASA workers in our area, and I know that one of them was talking to me about, she likes having the kids at court, even if sometimes she sits outside the court with the kids. And in a situation like that, I don't think there's any reason why, if everybody knows it's that kind of situation, the court couldn't be set up, that hearing couldn't be set up sort of bifurcated so that they could, address each child individually, and then maybe do a little bit with both of them together. I don't see any reason why that can't be done, especially when you've got CASA workers who are able to help that way.
Right, I think there was a comment in the back, yeah.
Well, and I've had kids participate in just part of the hearing, and we have a discussion pre-trial. For example, if you're looking for an adoptive home for a child and you're running into problems, addressing those problems in court may not be a good thing for the child to hear, And so I try to make an opportunity for the child to sort of have a little window of time where they get to say what they want to say, whatever it is. I need new shoes. I mean, it might be something really simple, really small, but then excusing them from the rest of the hearing. I haven't seen any indication from the kids that they feel like they're being excluded, because they're sort of used to that. There's grown-up issues and there's kid issues.
Yes, right. There are
And
going
so
to be
they're sort of
adult
used to
issues
it.
and there are going to be kids issues, right, yes. Go ahead.
I'm not gonna jump around, but how she said age, setting it at age is not right, I don't think personally, because certain kids have had to grow up sooner than they have, so they understand where things, for instance, when I was younger, I was left, I understand what things were going on, and if you're saying you have to be 14 to go to court, you know it, you've lived in that situation, you know what's going on. Personally, it should be the guardian ad litem, you know your kids, you can see where their maturity levels are, and if they're mature enough to go, they should be able to go.
Yeah, I think that there are a couple issues kind of going around here. It is absolutely appropriate that after you talk with your clients and explain to them sort of what is going to happen, to split the hearing, to have a portion of the hearing where the child comes in, talks to the judge about school, about placement, about the permanency plan, and then is excused from that hearing to talk about issues that could potentially harm the child. Now, I encourage you to kind of have a high standard as to what's going to harm the child, and really have a discussion with your client in advance. But if you feel like, and for example, your one client does not want her brother to hear about these issues, to actually have a discussion about that, and then excuse the one child from the court hearing. So the answer isn't to just exclude the child altogether, but to have the child involved to the extent that they can be involved, and then excuse the child. I think that's how you handle that issue. Other thoughts? Yeah.
What about the fact that they're not private hearings? I mean, for the girls up front, how would you feel if you have kids sitting from your school, from hearing all these private, intimate details while you have to sit there about your case? Would that change your opinion? Would it be okay?
Right. The judge can always clear the courtroom. I mean, I understand there are some states that have open courtrooms, and we're really trying to push that towards closer.
And they don't clear them.
Right. I mean, there's always the opportunity. I mean, if you as the guardian ad litem feel that, and you've talked to your client that your client does not want everyone in the courtroom here, you can ask the judge to clear the court. Now, I don't know if they're going to always do that, but that's a step that we as guardians ad litem can take. But I'd be interested to hear your feedback on what she just said.
I guess are you asking whether or not we would want to participate if we knew that would be talked about and other people would be there?
Right, I mean, as the foster, you know, the child that is dealing with this situation would, you know, because I have some kids that, you know, they don't feel comfortable to be in there because of those reasons. It's public, anybody can sit in, I mean, the press can sit in if they want, we don't have any control over that. And sometimes I think there's a lot of intimate things or things that you don't want everyone in your school to know, or you don't want, you know, people to be walking out, oh, I saw her in court today, and guess what? You know, because there's a mixture. We do all 3As, 3Bs, a lot of it at the same time. So you may have a kid who's in trouble for an MIP while we have another child in there who's dealing with abuse, neglect, and they're getting to hear this, and you have to see them. I mean, I don't know.
But how does the child being there change that?
It doesn't.
I mean, that information is going to come out one way or another. If
Not
your
to your friends
classmates,
at class.
sure, if your classmates are going to sit in and listen to the hearing, whether you're there or not, they're going to get the same information. I mean, it's not like the fact that you're there, there's going to be more information that comes out. You, as the juvenile, might offer something that you wouldn't if you weren't there, but the other information is going to be made available.
Then why should the whole rest of the world know more about your situation?
In other ways, other than asking the judge to clear the court, asking to approach the bench for a particular portion of the hearing, you know, that you think that, you know, that your client has access to, I do not want anyone to know this, asking to approach the bench, asking to go back to the chambers. You know, again, it's up to the discretion of the judge often, but to actually ask them, could it trigger in the judge's head that, this is private stuff. Go ahead.
I guess one of the only major issues that I ever really run into is, because I try to let my kids make the decision. Amanda and I are in the same jurisdiction, we kind of cut it off at 8, because I do agree with her on some levels that younger children don't understand the process. They don't understand why they can't go home with mom when mom comes to court, or go home with dad when dad comes to court. But the biggest issue I think I run into is when I try to explain to them what my role is as guardian ad litem, and I try to explain to them that I'm here to listen, but I also have to make a determination that's in your best interest, and they come to court and I tell the judge what they want, but I don't support what they want, and then they get upset, and then they shut down and don't want to talk to you anymore. And I think that's the major issue I run into with the kids being in court, because ultimately my job as guardian ad litem is not necessarily to do what they want. I have to do what's best for them. And no matter how much you explain that to them, at some children, when they come to court, when they hear you say, well, this is what my client wants, but I don't agree that that's in their best interest, that you're done. They're done talking to you.
Is that in your GAL report? I mean, does it have to be said when a child is there?
We put them in our GAL reports, but the judge still wants to hear us on the record.
If I have a case like that, I like to have the child there, and I will tell my kid, I appreciate what you're saying, and I'm going to let the judge know. This is my position, but I'm also going to let the judge know, and I'm going to let the judge know that maybe you'd like to say something about it yourself and argue for yourself, which I've never had a kid say that. They've always been really happy to have the opportunity, and it's never closed the relationship I've had with the kid.
I'm sorry.
I guess what I was going to say is just having that conversation ahead of time, so that's not the first time you're hearing from the judge.
No, and we usually do. I mean, Amanda and I follow very strict policies in our offices. Once we're appointed, how much time we have before we have to meet with the child, and it's always before court. And I'm not saying that it happens in every single case, and I'm not even saying that to me it's a barrier for having them in court. But we're talking about concerns that we have as a group, and that is a major concern that I have, is that, because a lot of the times too, by the time I get this child, they've been in and out of the system a number of times, or they've been in the system in another jurisdiction, and they're placed in North Platte, and so then we get them because they've violated the law in North Platte. And they have so many people that have come in and out of their lives, and so many people that have no consistency for them. And so when you try to explain to them, this is my role, this is what I'm here to do, and they feel like, okay, great, I have someone on my side, and then you go into court and you say, well, this is what the child wants, but I can't, in all good conscience, agree that's in their best interest. Sometimes that does cause that problem.
Yes.
Well, and the reality, though, is that if your opinion as a guardian ad litem is greatly divergent from the child, then the child's entitled to counseling. And so you have to step back as the guardian ad litem at that point and recognize that your child's best interest is to be able to express their own thoughts and their own feelings about what's going on, even if you don't agree with them. And if you can't do that consistently with your role as guardian ad litem, then you have a responsibility to request the court-appointed counsel for the child so their views can be expressed.
And I think most kids would appreciate the fact that you are making that pitch for them, that you say, even though I don't agree with your position, I will request from the judge that you have an attorney appointed so that you can come to court and present your side of things to the judge. And kids, I think, appreciate that, saying even though we don't agree, you're doing what you can to help me.
Okay.
So.
Yeah, absolutely. And I think that, that your point is absolutely right. If there is such a a stark and I want to have a discussion about that too. And this could go on for hours and hours and hours, but but talking about at what point do you ask for alternative counsel? But I wanted to. I think there was another point here.
I was just going to say one of the issues I ran into because I know a 11-year-old boy that was going to be coming to court to tell what's going on who was interested. But the foster parent called me the night before and said he's doubled over with a stomach ache, got stressed out coming to court, and she said he's petrified. The judge was going to ask him something that his parents would hear his answer to, not they have to counsel. Just petrified about his parents' previous responses to, are you doing okay in the foster home? Because if he said that was okay, he felt like there was a betrayal to his parents. So we did a heads up and let the judge know ahead of time that he was, hesitant about answering certain questions.
And how did the judge handle that?
The judge handled it very well. He just kind of said how school and we could avoid the whole issue of placement or permanency because the child was just petrified and he had to do that.
Right. Allowing the child often to control how it happens can be helpful, and that requires you to have obviously a relationship with your client in advance, to be telling your client in advance about the court hearing, and we can talk about that. But any other points on the issue of guardian litem versus attorney or? Okay, so any other concerns that folks have about involving kids in their court hearings? Yes.
I just have a really quick question. I have kids that come, and they really want to talk, and we get in there, and the judge says, so, do you want to tell me something? Not a word. They clam up, and I've talked to the judge, this kid really wants to do this, and I'm really interested if other people have a different approach to get them. We try to maybe ask them a few questions, or I, as guardian ad litem, say, well, remember, you wanted to ask the judge about this? But I get probably most of my teenagers get in there, they really want to do it, and then they just lose it.
All depending on age, you can help your client do an outline of things that he or she wants to talk about. And then if they do clam up, always have that outline, and either they can go to it and start talking, or if not, then you can ask them, well, can I go through your outline that you have already said and talk to the judge and kind of give the judge's points. But it happens all the time with my clients too. Yeah.
And I think that where they, I suggest, well, do you want to write a letter to the judge that you can read, or someone can read, and that's, they understand that better than that, but it's the same thing.
Right.
And they feel much more comfortable then, especially if it's in a letter mode, so it's kind of distancing a little bit more.
And I think kids would be more willing to talk if they were private hearings. I think you get in there and they want to do it. You get in there and you have this huge audience. And, then they're, I think they get nervous. I don't know that I want to say this or say that. Or, and I think it would be great if we had closed courts and juvenile out here. I think it would give the kids more opportunity to be able to talk, to say what they want to say without feeling they have to be on the city.
Are there any judges in your jurisdictions that would hear that would allow the child and the guardian ad litem to come into chambers to have a discussion?
Not really anymore. Everything has to be recorded.
Okay. Okay. It all depends on the judge. There are some ethical issues, ex parte, but you can sort of work through those issues if you get the consent of all parties, or if you tape it, but other things. But I understand. It is hard to have open hearings in these kinds of cases. We're really trying to push so that cases are closed. Yes.
Well, and I think there are some things that you could do with the physical environment a little bit. bit. For example, you have the child's back to the rest of the courtroom, talk to the judge about the possibility of them coming down to the table where the child's at, asking for the child to be able to make all their comments, sitting in close physical proximity to the guardian ad litem, and the judge being directly across from them. I mean, those aren't huge things, but from a child's perspective, it sort of makes everything a little bit smaller, a little bit more intimate, even if there are a bunch of people. They're not looking at them. I would be very hesitant to have a child come to court if it was expected that they would, for example, have to get on the witness stand to tell the court what they wanted. And it's a whole different physical environment, which has a huge impact on the child's ability to express themselves.
Absolutely. Go ahead.
Yeah, our judge is really good. He doesn't put the kids on the stand. We just he has a conversation at the table. And I've even had kids that hold my hand when we're trying to run times at church. So hold their hand and then he rattles. You know, it just so they can.
Excellent. Other concerns? Right, we kind of talked about your role. So, I just put this up here. You know, I got it out of your guidelines. Pulled them off of your site about the duties, and I think I pulled off the ones that really have to do with how to involve kids in their court hearings. You have to talk to your child in advance, at least. These are actually a bit more general, but after you are appointed, going to see your client at least 2 weeks after you have been appointed, to really talk about that issue of role. Your role as a guardian ad litem, the child has to understand about being an advocate, as opposed to being an attorney that represents exactly what the child wants. It's very clear that during that first appointment, and then at every appointment afterward. I mean, at every time that you talk to your client afterwards, going over again what your role is, so the child understands, and it helps to sort of address the issue of going into court and you having to advocate for what you think is in the child's best interest, even if it's not what the child exactly thinks. You know what? And it's also interesting that we've talked to kids about that, and kids, and we've talked to them because we've told them obviously the judge isn't always going to do what you ask. How do you feel about that? And they feel that as long as they feel heard, as long as their opinion is taken into account, and that the judge or even the guardian ad litem explains, this is the role I have, and I'm taking what you say into account, and here's why I'm advocating, or I'm going to decide this. And the kids feel empowered as long as you take into account what they have to say and they understand that. So I wanted to sort of put that out there. And if you all have any other comments to add about that, I mean, having a guardian ad litem. You want to add anything about that? Okay. So I think that that's important. Talking to your client if there's going to be a placement change. Are you given notice in advance of the placement changes? I see. There are sometimes. Okay. There are some states actually have statutes, you know, that require that. I don't know. I didn't see a statute that required it.
Yeah, if they're removed in an emergency base, I think our statute says within 7 days they have to give us written notification.
Okay.
But like if they're in a foster placement and they're moved to shelter that night because of, say, a behavior or something.
Right. Obviously, they can't tell you that.
Yeah, they have 7 days to technically tell us, so you don't always hear about it. We may have court the next day, so then you hear about it 2 minutes, 5 minutes before, you know, you're walking in.
Right.
And I think that
if it's possible, I mean, I think it's so important. I mean, you know, as again, we're trying to involve kids more in permanency planning, that if there's a change in placement can have such an impact on a child. They often change schools, and so it's important that we as guardian ad litem get out there and see our clients after there's a change of placement or before, and try and find out, is this what our client wants? How come there was a change of placement? Even explaining to the child why there was a change in placement. And then if the child does not want the change of placement, asking for a hearing. You know, calling the child welfare agency to task. Why are they changing placements again? How come they are changing schools? And really talking about the impact on the child. And then here's, in terms of going to your court hearing. So obviously, as a guardian ad litem, you have to attend all of your court hearings, and then advocate for the child to be present as appropriate. So I want to talk about when it's appropriate. So we've kind of talked about sort of why it's a good idea, and we've talked about our concerns. And as I said, I'm not standing up here saying that all kids should come to all cases, but there should be some type of criteria that's sort of across the board. And I want to get ideas from you about what are the kinds of things that should play a role in if you are going to decide if your client comes to court or not.
I think the type of case, if it's a 3B, a 1 or a 2,
A 3B, a 1 or 2, tell me what
uncontrollable misdemeanor felony. They need to be there, no matter what they're required, they have to. I think in those situations, there really is no question on that. But then when you're dealing with our 3A, which is abuse and neglect, I think that's when we have to start taking the child and everything else into consideration.
Absolutely. Okay, so the kind of hearing, and that's the last one on there. Absolutely. I mean, if we're talking about a termination of parental rights case, if we're talking about an adjudication, there's a question if the child should be present or not. And again, it's what are the facts of the case? What is the child going to be required to do? What is the child going to have to hear about? And just to go back, the law, the Child and Family Services Improvement Act, exclusively talks about the permanency hearing. So it does not address the the requirement of the judge to talk to the child during an adjudication or a TPR. It talks about the permanency hearings. When you're talking about what the permanency plan is, when you're talking about how the placement, how school is, those are the kinds of hearings that law is trying to address about when kids should come to court. So absolutely the kind of hearing that is scheduled. Other things, other criteria that you would put into place for deciding if a child should come to court or not.
I think the distance and the time that a judge spends on a court hearing. I know for us, we have a lot of kids placed like Omaha, Lincoln. So you're having them 3 to 4 hour drive and their hearing maybe 10 minutes and then they're right back in the car for another 3 to 4 hour drive. Maybe trying to come up with other ideas by either webcam or phone or something else to get them involved, but still taking those things into consideration.
Yeah, I think that's an interesting point. Transportation is often said is an issue, and kids have been kept out of court because of the who's going to transport a child, and again, how long is it going to be for the child to drive there? I think it's important for us to really be creative when it comes to who's going to transport the child. Who currently transports the child to and from court hearings? Is there one?
There's like Prince of the Road, there's Midwest, they're just agencies if they're placed like within, I guess 30 miles or out or more, one of those will transport our children. If they're within the jurisdiction, then usually the caseworker or the foster parent would bring them.
Okay.
Or the group home.
Right. Because we're really trying to encourage foster parents to be present more and more at these hearings. So having that parent bring the child to and from court. Asking the child, is there anyone that could bring you to court? If it's an older child, can you hop on the bus and come? So really being creative as to how we get kids to and from our court hearings. If the court hearing is far, what are some alternatives to having you present?
I usually make arrangements with the placement. Usually we face it in group home situations. And so I usually make arrangements with the placement to have the child be available by telephone for the court to initiate them to participate by telephone.
Absolutely. It isn't ideal, obviously, but actually having the child call in. There are a couple states and there are a couple counties around the country that actually have an agreement with the schools that during the courting the child go to the guidance counselor's office and participate by phone or even by webcam. And so just trying to be creative when it comes to that. Any other ideas about transportation? Okay, other factors when you're trying to decide if a child's going to come in here. Other factors that would come into play. I think we talked about age. I think age is an appropriate one. I agree that I don't think that it should be sort of a bright line rule. All kids over the age of 10 can come to court. All kids under the age of 10. It should be a case by case, but age should absolutely be taken into account. Yeah.
Yes, I definitely agree with you with age and the situation and what will be talked about in court and everything should be taken into account. I think it's incredibly important that everybody at the table physically sees the child, even a baby. I mean, they need to, one, is be able to see them and understand that this is a person and not a case. And two, as our cases linger, they need to be able to see them grow up and see that, this toddler is growing up, or this, young person is, no longer in junior high, this is a teenager. We need to really be able to see this young person growing up.
Okay.
Sometimes what I'll do if I have a baby or a toddler, before the hearing starts as a preliminary matter, I get up and I take the child and I show the judge, I introduce them, this is so-and-so, and so you put a face, even though it's a baby and they aren't going to be taking part in the hearing, and then there's someone there to take them and leave. But I just want him to know.
I was just gonna say, they come with the foster parents when they're young, and coming with the foster parents is probably the best way to address it when they're young. They don't necessarily have to be sitting up at the table, but it's part of their life.
Absolutely, and I would agree. I mean, even having an infant present for at least one hearing, so the judge can see exactly who the case is about, and if the child is in care for a year or more, having the child come to court can show the judge this child needs permanency. This child is growing up while in care. So excellent.
I think too. I think at least in our county, the foster care they send pictures to the judge every so many months of the child and that the judge is having there on the bench in their file and stuff, which is another good way if the child can't be there for some reason or something that they can still put the name to the case.
I ask the parents or the foster parents to bring a picture when the case is first presented, and that's entered as evidence and put inside the court's file, so that we've got a picture. Even if the child isn't consistently there, if the child's there once or twice, and then he's got this picture, it really jogs their memory. It makes the child more real.
Yeah, absolutely. Yes.
I kind of take it a step farther. You have to visit the child, and so with digital photography, it's easy. I take a picture of them and I attach the pictures to my guardian ad litem report.
Excellent. Okay.
So I think the judges really like that because, again, attaching a face to the case, it makes a big difference, I think, even in the attitude of the judges. Just if the child can't be there for whatever reason, at least having a good photograph there to see, it's a good idea.
Yeah, absolutely. Okay, we don't have a ton of time. You have 2 minutes. I have 2 minutes, of course. Okay, so the next 2 slides are just tips that we put in here as to, because as I said, we're not talking about just plopping a child down in court without any support structure. We need to be preparing our clients for coming to court. Too many times I've talked to kids and they have said, I don't have any idea what's going to happen going into court. So it's important to understand just even the smallest things about where they're going to sit, who's going to be there, what clothes to wear, what questions are going to be asked. And so here are just some ideas of anything that's, again, talking about what your role is going to be to ensure that they understand that as you're standing up there talking about what you think is in their best interest, that is your role, and that they can speak about stuff that they want or even ask for an attorney other than you. Let's see. So, and also telling the youth that you will tell the judge what he or she wants. The child welfare agency report, I always get a lot of discussion about that one. Actually showing the child or telling the child what the child welfare agency's report says about either their parents or if they're older and their parents' rights are terminated, what the agency's report says about them, and to really be able to tell the child has the ability to say, is that right? Is that wrong? Is there anything else the judge should know about what is in the agency report? So again, it's really empowering to the child to be able to say, well, I don't agree with that, or here's how that actually happened, and to feel that they have a voice in court to the judge, and it's not just the agency's report that the child gets. Anything finally? And then afterwards, it's so key that we, as a guardian ad litem, take the opportunity to speak to our clients afterwards. Did you understand what happened during the court hearing? Here is a copy of the judge's order. And asking the child, do they have any questions about that? And if you as a guardian ad litem think the child needs more than just you talking, to ensure that either the foster parent or the caseworker get the child either into counseling or just talk to the child about what happened during that court hearing. And then if the child has any questions in the days to follow, ensuring the child is able to contact you. And all this ensures that the child's that the child's participation is meaningful. Okay. I don't think okay. Okay. This is who I am. If you have any questions, again, all of the PowerPoints are in your drive, this dump drive, and a couple articles as well to kind of go into a lot more detail about the guardian ad litem role. So I appreciate everyone.